Greetings and good evening, beautiful people. Thank you so much for joining us this evening. I hope you're having a fantastic day and week. Welcome to our live weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJAC YouTube channel. This is the only live reading of the California Reparations Task Force final report on YouTube. The final report of the first in the nation California Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s. Equally important is also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing every page of it to you, chapter by chapter, every week on Thursdays at 7 p.m. PST, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with the support from the reparations organizing and mobilizing team at the Coalition for Just and Equitable California. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more info on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the act to end current slavery in California state prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now, I need you to do three things. First, connect to our YouTube channel by liking this video, hitting the bell for reminders, and subscribing to our YouTube channel. Second, get connected to us on social media by following CJEC on Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Finally, get informed and involved. To do that, visit www.cjec-official.org to sign up for current and accurate California reparations news and info on our Get Involved page and support our work by volunteering and or donating. To donate, just click the Donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. You can learn more about our fiscal sponsor, the California Black Women's Health Project, at www.cabwhp.org. By way of introduction, my name is Iris. I live in Santa Rosa, California, and I am from the Bay Area, California. I am a volunteer reparations advocate with CJEC's reparations organizing and mobilizing team. The agenda for today, chapter 39, Unjust Legal System, Statutes, and Case Law, part 2. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website, www.cjec-official.org/reports. Okay, we are just about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch their readings of the first report on their channel at ETM Media Group on YouTube and on our website at www.cjec-official.org/videos. Second, for those of you who don't know, historic reparations legislation in California is here and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward this year. To read the bill, visit www.cjec-official.org/advocacy. Third, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During this 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bill. So to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Last but not least, special thanks to CJEC's reparations organizing and mobilizing team, specifically our volunteer final report readers. And without further ado, Chapter 39, Part 2 of the California Reparations Task Force final report. 1866. Act to protect all persons in the United States in their civil rights and furnish the means of their vindication. 1866, Civil Rights Act. Summary of the law. The 1866 Civil Rights Act guaranteed citizenship to everyone born in the United States, not subject to a foreign power, regardless of race or previous condition of slavery or involuntary servitude. It also guaranteed each citizen equal protection under the law and the same civil rights enjoyed by, quote, white citizens, unquote. Violations of rights guaranteed by the act were punishable by fines and imprisonment. The federal courts had exclusive jurisdiction over actions to enforce the rights guaranteed by the act. Impact of the law. The act was introduced by Senator Lyman Trumbull of Illinois to guarantee equality of citizenship for African Americans. He believed the legislation was needed because, quote, the abstract truths and principles of the 13th Amendment meant nothing unless the persons who are to be affected have some means of availing themselves of their benefits. The act was vetoed by President Andrew Johnson, but Congress overrode his veto. The act's citizenship provision was the template for the 14th Amendment that was ratified 2 years later. Subsequent history. The 1866 Civil Rights Act was incorporated into the 1870 Civil Rights Act as Section 18. 1871, Blyeu versus United States, 80 U.S. 581. Summary of facts and issues. The petitioners, 2 white men who murdered 4 members of an African-American family in Kentucky, were convicted of the murder of one of the victims in federal court. One of the victims made a dying declaration identifying the killers before dying from his wounds. Another witness, a young girl who escaped the killers, also identified the defendants. Initially, the case was brought in state court, but the matter was removed to the federal court under the Civil Rights Act of 1866. The case was removed because Kentucky law prohibited African Americans from testifying against white people. Therefore, in a state proceeding, the 2 key witnesses would not be able to testify against the petitioners. Because that law precluded the witnesses from testifying because of their race, it affected their civil rights under the 1866 Civil Rights Act. Therefore, the matter came within the federal court's jurisdiction under the act. The petitioners objected, and following their conviction, they filed a petition. The Supreme Court reversed their convictions. The court explained that the 1866 Civil Rights Act was not so broad as to allow the federal courts to assume jurisdiction in every matter in which an African American person was involved as a witness. It only applied to matters that affected the rights declared declared in the 1866 Act, and serving as a witness did not meet the definition of a cause, quote, affecting, unquote, a right guaranteed by the 1866 Civil Rights Act. Impact of the ruling. The dissenting opinion argued that the application of the 1866 Civil Rights Act to the circumstances of this case was necessary to declare the equality of African Americans and to, quote, counteract those unjust and discriminating laws of some of the states, unquote. That deprived African Americans, quote, the right and privileges enjoyed by white citizens, unquote. The court's decision deprived a whole class of the community of the right to serve as witnesses in cases where crimes have been committed against members of their community. Quote, to refuse their evidence and their sworn complaints is to brand them with a badge of slavery, unquote. And, quote, it gives unrestricted license and impunity to vindictive outlaws and felons to rush upon these helpless people and kill and slay them at will, as was done in this case, unquote. 1875, United States versus Cruikshank, 92, U.S. 542. Summary of facts and issues. The case arose out of the Colfax massacre, where at least 70 African Americans who were protecting the state house in Louisiana after a contentious and close gubernatorial election were murdered by white militia. None of these underlying facts of the massacre were included in the court's opinion. Rather, the court's opinion focused only on whether the allegations in the 16-count indictment charging the defendants with depriving African Americans of their rights under the Civil Rights Act of 1870 were sufficient to sustain the defendants' convictions. The court found none of the allegations were sufficient for a variety of reasons. Specifically, it determined that several of the allegations failed to state an offense for which the defendants could be charged under the 1870 Civil Rights Act, because the 14th Amendment did not apply to actions of individuals, only the actions of states. It also found that the First Amendment and the Second Amendment were limits on the national government that did not apply to the states. Additionally, the right to vote was a right afforded by the states, not the federal government, which only guaranteed through the 15th Amendment that the right to vote could not be denied based on race. With regard to the remaining allegations in the indictment, the court determined that they were too factually vague to provide the defendants with sufficient information to prepare a defense. Therefore, they were too vague to support the convictions. Impact of the ruling. The court's decision rendered the 1870 Civil Rights Act ineffective in stopping violence against African Americans by restricting the federal court's authority to enforce the rights delineated in the act. African Americans had to rely on hostile state governmental institutions to enforce and protect their civil rights. The decision also limited the 14th Amendment to state actions and held that the First, Second, Fifth, Sixth, and the Eighth Amendments only applied to the federal government. It also held that the federal government could only guarantee that the franchise was not denied based on race. States were free to regulate the franchise with facially neutral voting restrictions that were not explicitly based on race. This resulted in a variety of regulations and intimidation campaigns that severely restricted African Americans' right to vote in Southern states for decades. Subsequent history. The court's decision limiting the limiting the Bill of Rights to the federal government was overruled by Gitlow versus New York, 1925 268 U.S. 652, which held that the First Amendment applied to the states by incorporation through the 14th Amendment. The Voting Rights Act of 1965 provided specific protections for African Americans against facially neutral regulations and restricted African Americans' voting rights in Southern states. (1883) New York versus Campagnie Generale Transatlantique 107 US 59. Summary of facts and issues. The city and county of New York filed suit to cover the sum of $1 tax for each alien passenger brought into New York aboard the defendant's vessels on the grounds that the passengers were imports to which the tax applied. The plaintiffs argued that the tax was an inspection fee authorized under Article 1, Section 9 of the U.S. Constitution. The lower court rejected the claim. The United States Supreme Court affirmed. The court explained that the passengers on the defendant's vessels were free human beings who immigrated to the United States. They were not enslaved people who were imported into the country. Therefore, they were not imports to which an inspection fee would apply. Impact of the ruling. The court's ruling made it clear that the provision of U.S. Constitution, Article 1, Section 9, which allowed states to pass inspection laws for imports, applied to the importation of slaves, of enslaved people, because they were not free human beings and were considered property. Because the passengers were free human beings and not property, New York could not impose an inspection fee on the defendants for transporting them. United States versus Harris, 106 U.S. 629. Summary of facts and issues. The case arose from an incident involving a group of 20 white men in Tennessee attacking 4 African American men who had been arrested and charged with unspecified offenses and killing one of the victims in a 4-count federal indictment. The 20 men were charged with depriving the African American men of their rights to equal protection under the law in violation of the Ku Klux Klan Act. Because the lower court judges had a division of opinion as to the constitutionality of the Ku Klux Klan Act, the prosecuting attorney filed a certificate of division in the U.S. Supreme Court asking the court to decide the issue. The court concluded that the Ku Klux Klan, which regulated the violent conduct out of individuals against African Americans, was unconstitutional because there were no provisions in the Constitution that supported the enactment of statute. Additionally, even if the Ku Klux Klan Act could be supported by the 13th Amendment, because a white citizen could conceivably be prosecuted under the act for violating the rights of of another white person, it went beyond the time limits of the 13th Amendment's protection of only African Americans, because it was overboard and it was unconstitutional. Impact of the ruling. The court invalidated one of the primary laws enacted to protect African Americans from violence by organizations like the Ku Klux Klan. The court's decision affirmed the holding in U.S. versus Cruikshank, 1875-92 U.S. 542, that the 14th Amendment did not apply to private actors, but only to state actors. The court's decision also meant that any congressional act based on the 13th Amendment uh, had to be limited to African Americans. The facially as applied to be constitutional. If the congressional act could be applied to acts committed against white people by other race, by other white people, it could not be constitutionally grounded for the 13th Amendment. (1886) Yikwo versus Hopkins, 188 U.S. 356. Summary of facts and issues. The city and county of San Francisco arrested and imprisoned two of its Chinese residents for violating ordinances that regulated where laundry facilities could be located. One ordinance required laundry operators to obtain permission from the board of directors of it, if the laundry facility was located in a building constructed of wood. The petitioners were charged with violating this ordinance, convicted, and imprisoned. One filed a petition for writ error, asking the court to determine whether he had been denied his rights under the Constitution. The court held that the ordinance under which the petitioner was prosecuted violated the Equal Protection Clause of the 14th Amendment, because in particular, because in actual operation, it was directed, quote, so exclusively against a particular class of persons as to warrant and require the conclusion that, end quote, it amounted to a practical denial of that equal protection of laws secured by the 14th Amendment. The violation of the Equal Protection Clause required the petitioner's immediate release. Impact of the ruling. The Supreme Court's unanimous decision applied the Equal Protection Clause to invalidate a facially neutral law that was being applied in a racially discriminatory manner. 1900, Carter versus Texas. 177 U.S. 442. Summary of facts and issues. An African American man was indeed indicated, or excuse me, indicted by a grand jury for the murder of an African American woman. Before he was arraigned, the defendant filed a motion to quash the incident on the grounds that although African Americans constituted about 25% of the voters in the country, the grand jury that returned his indictment was composed exclusively of white people. The defendant sought to introduce witnesses to verify his claim, but the Central Court denied his permission. The Supreme Court held that a motion to quash the indictment was the proper vehicle to challenge the grand jury indictment based on the exclusion of African Americans. The defendant duly alleged that African Americans were excluded from the grand jury based on race, and the court refused to hear any evidence on the subject. The defendant had no opportunity to challenge the racial makeup of the grand jury before he was indicted and further indicted, and therefore the defendant's conviction was reversed. Impact of the ruling. The court reaffirmed the prior ruling under Strouder versus Virginia, 1879, 100 U.S. 303, that a state's systemic exclusion of African Americans from a grand jury violates the Equal Protection Clause of the 14th Amendment and of the United States Constitution. Where the grand jury was impaneled before the time was committed, a motion to quash indictments before the defendant is arraigned is a proper mode of presenting the constitutional objection. In 1903, Brownsfield versus South Carolina, 189 U.S. 426. Summary of facts and issues. The defendant filed a habeas petition seeking to overturn his conviction on the grounds that the grand jury returned his indictment was all white and that all African Americans were excluded, violating his right to equal protection. The defendant noted that in a community where 80% of the registered voters were African American, no African Americans served on the grand jury. The court denied the defendant's petition because the record did not support the African American defendant's allegation that African Americans were intentionally excluded from the jury pool. Impact of the ruling. The court's decision did not address the defendant's claim regarding the number of African American voters in the county compared to the number of white voters. The court seemed to require an offer of proof of the actual exclusion of the African Americans from the grand jury accompany the motion to quash the challenge to the lower court's refusal to hear that evidence in order for a defendant to establish a violation of equal protection. The court's ruling is an example of judicial restraint and a strict reading of the record and procedural requirements in order to bring discrimination claims. 1904, Rogers versus Alabama, 192 U.S. 226. Summary of facts and issues. The petitioner, who was indicted for murder, filed a motion to quash the indictment because all African Americans have been excluded from the grand jury that indicted him. The jury commissioners appointed to select the grand jury excluded all African Americans on the grounds that they lacked the right to serve as electors in the state of Alabama by the provisions of the new Constitution of Alabama and therefore could not serve as grand jurors. The Supreme Court applied its prior decision in Carter versus Texas, 1900, 177 U.S. 442, which it admonished the state's court for not applying and held that the exclusion of African Americans from a grand jury violates the Equal Protection Clause. It also noted that whether a citizen could serve as a grand juror was not dependent on their qualifications as an elector. The petitioner's conviction was reversed. Impact of ruling. The court reaffirmed its prior ruling in Carter versus Texas, 1900, 177 U.S. 442, commenting that the state of Alabama should have done so too. In this case, as in Carter, decided 4 years earlier, the court held that a challenge to a criminal indictment based on racial discrimination could be raised in a motion to quash that indictment. 1906, Martin versus Texas, 200 U.S. 316. Summary of issues. An African American man accused of murder moved to quash a trial panel on the grounds that all African American jurors have been excluded from his trial jury because of their race. The court ruled that while the 14th Amendment prohibits the state officials, including court administrators, from excluding potential jurors from a trial or grand jury solely because of their race, Martin did not provide sufficient specific evidence of a policy of discriminatory exclusion, evidence that there were no African Americans on the jury trial was insufficient evidence of affirmative system exclusion. Impact of ruling. This decision affirmed the right of racial minorities to challenge discriminatory practices in impaneling a jury. However, the court's requirement of a showing of specific evidence of discriminatory intent set a high bar for a criminal defendant to reach, a standard that was eased in later decisions. Subsequent history. In Batson versus Kentucky, 1986, 476, U.S. 79, the court provided a number of rules regarding whether strikes of racial minority members from trial jury panels are discriminatory, including whether a prosecutor has exercised preemptory challenges to remove members of the defendant's race on account of their race. 1908, Battle versus United States, 209 U.S. 36. Summary of facts and issues. The petitioner was convicted of murder. He argued that the trial court erred when it interrupted his counsel in making an argument that was based on race. The Supreme Court held that there was no error. In the interests of the administration of justice, judges may interrupt counsel when their argument makes an appeal to racial prejudice. Impact of ruling. The courts have the general discretion to regulate trials to ensure justice. Where an attorney expressly denigrates the testimony of a witness based on their race using racial epithet, the trial judge has discretion to admonish the attorney. Ex parte Young, 209 U.S. 123. Summary of facts and issues. Ex parte Young arose out of a dispute among shareholders in a railway company. The railway company, the Attorney General of Minnesota, members of the Warehouse and Railway Commission, and shippers of freight. Two shareholders challenged a new Minnesota law that reduced the shipping rates that railroads could charge for freight. The shareholders claimed that the new rates were unconstitutional and obtained a federal injunction forbidding the enforcement of the new rates. Young appeared in the federal court and objected on the 11th Amendment grounds. While the federal injunction was in place, Young, the Attorney General for Minnesota, initiated an enforcement action in state court, seeking to writ of mandamus to publish and enforce the new rates. The state court issued an alternative writ. Upon notification of the state court action, the federal court held Young in contempt and imprisoned him. Young filed a petition for writ of habeas corpus on the grounds that Minnesota's sovereign immunity applied and the suit against him was improper based on the 11th Amendment. The Supreme Court disagreed. Where a state official uses the latter, state official uses the name of someone, excuse me, where a state official uses the name of the state to enforce a constitutional act that injures a complainant, and if the act violates the federal constitution, the state official is subject to suit in their individual capacity. Quote, the state has no power to impart to him any immunity, end quote. Impact of the ruling. If government officials attempt to enforce an unconstitutional law, sovereign immunity does not protect them from being sued in their individual capacity for the harms they cause. 1909, Thomas versus Texas, 212 U.S. 278. Summary of facts and issues. Thomas, an African American man, was convicted of murder and sentenced to death. He contested the conviction on the basis that although there were African American members of the jury pool, the commissioners did not pull their names and excluded them from the jury. The Supreme Court upheld the conviction on the basis that there had been intentional discrimination against or exclusion of African Americans from the grand jury indicting and the trial jury convicting. Thomas or convicting. Um, Thomas, since there was an African American grand juror and there were African American members of the trial jury pool. The court held that the petitioner's argument that the African American members of the jury pool were not given equal consideration as white members of the jury pool is not sufficient evidence for discrimination. Impact of ruling. The court reaffirmed that there is no right to a grand jury that includes people of the defendant's race and that there must be some evidence that the jury commissioners engaged in affirmative discriminatory acts. 1910, Franklin versus South Carolina, 218 U.S. 161. Summary of facts and issues. South Carolina passed a statute giving the right to jury commissioners to select electors of, quote, good moral character, unquote, that they deem qualified to serve as jurors. Defendant was convicted of murder and challenged to the indictment on the basis that the statute served to create a biased grand jury. The court held that the state's action to create new uh oh, excuse me. Defendant was convicted of murder and challenged the indictment on the basis that the statute served to create a biased grand jury. The court held that a state's action to create new criteria for impaneling juries does not violate the U.S. Constitution, even if the effect is to render different groups of people ineligible for jury service, so long as the statute is race neutral. Impact of ruling. The court upheld South Carolina's change in juror qualifications, which granted large discretion to exclude people who were previously eligible to serve on grand juries, continuing its trend of upholding statutes that could have discriminatory impact on racial minorities, so long as the statute was race neutral on its face. 1923. Moore versus Dempsey, 261 U.S. 86. Summary of facts and issues. A group of white men attacked and fired upon African American churchgoers in Arkansas in the after in Arkansas. In the aftermath of the shooting, several African Americans and a white man were killed. 5 African American men were charged with the white man's murder. The governor appointed a committee to investigate the incident. The committee identified and indicted 5 African American men for the murder of the white man. The committee also issued inflammatory statements describing the incident as a deliberately planned insurrection by African Americans for the purpose of killing white people. Shortly after the men's arrest, a mob marched to the jail for the purpose of lynching them. They were only prevented from doing so by federal troops. The committee stated that the men were not lynched only because the law would be carried out. Witnesses later said that the committee called African American witnesses and tortured them until they would say until they, quote, would say what was wanted, end quote. The torture of these witnesses provided the, quote, evidence, end quote, needed for all white juries to indict and convict the defendants. After a 45-minute trial and less than 5 minutes of jury deliberation, the trial was surrounded by a mob, according to the court. Quote, no juryman could have voted for an acquittal and continue to live in Phillips County, end quote. Impact of ruling. The Supreme Court held that since the trial was so influenced by the mob, the defendants were deprived of their due process rights under the Fifth Amendment to the U.S. Constitution, which ensures that the procedures used to convict the defendant satisfies the demands of justice. The court pointed out that a state court's conviction is not entitled to conclusive weight if a defendant's constitutional rights were being violated in the execution of a trial. 1931, Aldridge versus United States, 283 U.S. 308. Summary of facts and issues. An African-American man was convicted and sentenced to death for murdering a white police officer. The trial court refused to ask prospective juries during the voir dire whether any of them might be prejudiced against the defendant because of his race. Impact of ruling. The U.S. Supreme Court overturned the conviction because the trial failed to cover the subject of racial prejudice during the voir dire. The court held that such an inquiry should have been made related to the racial prejudice during the examination of potential jurors, but noted the trial judge has broad discretion to determine which specific questions to ask. Subsequent history. In Rosales Lopez versus United States, 451 U.S. 182, the court limited when an inquiry into racial or ethnic prejudice is required in crimes involving interracial violence. 1932, Powell versus Alabama, 287 U.S. 45. Summary of facts and issues. 9 African-American boys described as young, ignorant, and described as, quote, young, ignorant, and illiterate, unquote, were convicted and sentenced to death for allegedly raping 2 white women on a freight train to Scottsboro, Alabama. The defendants were tried in a total of 3 trials that were completed in a single day. The Alabama court did not inquire or provide them with time to secure counsel, and the counsel was not secured until the morning of the trial. Impact of the ruling. The U.S. Supreme Court reversed the convictions of the boys and remanded the cases for further proceedings. The court held that due process rights under the 14th Amendment had been violated because the defendants were not given reasonable time and fair opportunity to secure counsel of their choice, end quote. Subsequent history. A series of retrials followed Powell. 2 of the boys were reconvicted and sentenced to death in late 1933. The court again overturned the 2 verdicts in Norris versus Alabama, concluding that the systematic exclusion of African-American men from the jury denied them a fair trial. After Norris, 4 of the defendants were again retried and convicted, while another 4 were released after the charges against them were dropped in 1937. The unfair treatment of African-American men in this case helped spur the civil rights movement. 1935, Norris versus Alabama, 294 U.S. 587. Summary of facts and issues. Norris was one of 8 African American boys indicted and convicted of rape. The Supreme Court affirmed the principles it had previously reached out to Carter versus Texas, 1900, 177 U.S. 442, holding that systematic exclusion of African Americans from jury service solely on the basis of their race violates criminal defendants' equal protection rights. The court held that the evidence showed that the application of the state statute listing junior qualifications had served to exclude African Americans from jury service for a number of years. Impact of ruling. The court affirmed its prior rulings that if a criminal defendant is able to present a prima facie case that members of his race were systemically excluded from jury pool on the basis of their race, his constitutional rights were violated, absent a compelling showing of evidence from the state. The court additionally ruled that federal courts had jurisdiction to review, validate defendants' constitutional rights in state court. Subsequent history. The court in Hernandez versus New York, 1991, 500 U.S. 352, 353 through 354, later distinguished its holding by clarifying that a state court is entitled to deference when a defendant brings a challenge to prosecutors' preemptory dismissal of jurors under Batson versus Kentucky, 1986, 476 U.S. 79, and that a defendant is not entitled to, quote, independent, end quote, appellate review of a state trial court denial of a Batson claim. 1936, Brown versus Mississippi, 297 U.S. 278. Summary of facts and issues. Petitioners were 3 African American men who were indicted for murder. The defendants testified that the police officers, though, through brutal force, extracted false confessions that they were responsible for the murder. Other than the false confessions, there was no other evidence that would have supported a conviction for the murder. Still, the trial court allowed the confessions to be received into evidence and submitted the case to the jury. The petitioners were convicted and sentenced to death. They filed a petition in the United States Supreme Court. The court agreed that the use of confessions obtained through torture to secure the petitioner's convictions and sentence was a clear denial of due process. Quote, the due process clause requires that the state action, whether through one agency or another, shall be consistent with the fundamental principles of liberty and justice, which lie at the base of all our civil and political institutions. It would be difficult to conceive of methods more revolting to the sense of justice than those taken to procure the confessions of these petitioners, end quote. Impact of ruling. The court's decision reaffirmed that the fundamental requirement for all trials is fairness or due process. 1940, Chambers versus Florida, 309 U.S. 227. Summary of facts and issues. After an elderly white man was murdered, law enforcement officers employed dragnet tactics and detained between 25 and 40 African American men living in that community. Quote, for 5 days, petitioners were subjected to interrogations culminating in Saturday's all-night examination. Over a period of 5 days, they steadily refused to confess and disclaimed any guilt, end quote. Eventually, they, quote, broke, end quote, and confessed. Three of the petitioners pleaded guilty, and one was convicted at trial based on the confession. All four were sentenced to death. On review, the United States Supreme Court reversed their convictions. The court explained that the process the officers put the petitioners through were, quote, lawless, end quote, and violated due process. Quote, due process of law, uh, preserved for all by our Constitution commands that no such practice as that disclosed by this record shall send any accused to his death, end quote. Impact of ruling. The court's decision reinforced that all states must adhere to due process principles when securing convictions. 1942, Ward versus Texas, 316 U.S. 547. Summary of facts and issues. Petitioner, an African American man, was indicted for the murder of a white man. During the first trial, the jury did not reach a verdict. During the second trial, the petitioner was convicted of murder without malice. Petitioner contended that his confession was coerced, alleging that it was signed only after he had been arrested without a warrant, taken from his home, driven 3 days from county to county, placed in a jail more than 100 miles from his home, questioned continuously and beaten, whipped, and burned by the officer to whom the confession was finally made, end quote. The Supreme Court reversed its conviction, holding that the use of confessions obtained under circumstances where the defendant was threatened with mob violence, moved to various countries, isolated, and questioned continuously, questioned continuously, is a denial of due process. Impact of ruling. The court's decision reaffirmed that the court would not uphold convictions based on confessions that were coerced. The petitioner in Ward was arrested by officers without a warrant in a county where they did not have authority to make an arrest. These actions, combined with the coercive techniques, denied due process and required reversal. 1945, Atkins versus Texas, 325 U.S. 398. Summary of facts and issues. Petitioner, an African American man, was convicted of murder and sentenced to death by a nearly entirely white jury in Dallas County, Texas. At the time, Dallas County's population was 15.5% African American, yet only one African American sat on the 12-person grand jury from a grand jury panel list of 16 people. Petitioner challenged the conviction on equal protection and due process grounds, claiming that jury commissioners arbitrarily and purposefully limited the number of African Americans on juries. The court reviewed statements by jury commissioners, determined that the commissioners followed the court's previous decisions and held that, quote, purposeful discrimination is not sustained by showing that on a single grand jury, the number of members of one race is less than that race's proportion of the eligible individuals, end quote. Impact of ruling. In its ruling, the court emphasized that a defendant challenging jury composition must show that there was a purpose to discriminate, which can be proven by historical or systemic exclusion, that and that a single instance of disproportionality in a jury is not sufficient to establish a due process violation. 1948, Haley versus Ohio, 332 U.S. 596. Summary of facts and issues. A 15-year-old African-American boy was arrested for robbery that resulted in the death of the store owner and interrogated for 5 hours by 5 or 6 police officers in relays, during which time he was not able to communicate with counsel or his mother. After being shown the confessions of 2 other suspects, he himself confessed and he was convicted. The Supreme Court reversed the lower court's decision or conviction, explaining the age of the petitioner, the hours when he was grilled, the duration of his quizzing, the fact that he had no friend or counsel to advise him, the callous attitude of the police towards his rights, combine to convince us that this was a confession wrung from a child by means which the law could not sanction. Neither man nor child can be allowed to stand condemned by the methods which flat out constitutional requirements of due process of law, end quote. Impact of ruling. The court emphasized that Haley was a, a continuation of the principle in Chambers versus State of Florida, 1940, 309 U.S. 227, and other coerced confession cases. The court noted it would not uphold convictions where circumstances of the confession indicated that the confession was not freely and voluntarily given, explaining that the 14th Amendment prohibits the police from using the private secret custody of either man or child as a device for wringing confessions from them. And that will conclude tonight's reading of Chapter 39 of the California Reparations Task Force Final Report. Before you go, if you haven't done so already, don't forget to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, don't forget to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and Twitter at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and info on our Get Involved page. Get involved. Support our work by volunteering and or donating. To donate, just click the donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Thank you all so much for your time. I appreciate you all. We are closer to reparations than we have ever been in California. Have a great night.